Hello everybody. Today's discussion is going to cover parent-provider rules. I wanted to specify that we will not be discussing non-parent provider rules today. The location of our content today is found in the Manuals of Policies and Procedures in 30-763.45, and I'll read them to you right now. When the recipient is under 18 years of age and is living with the recipient's parents, who has a legal duty under the Family Code to provide for the care of his or her child, the IHSS specified in 30-763.456 may be purchased from a parent under the following condition. The parent has left full-time employment or is prevented from obtaining full-time employment because no other suitable provider is available, and the inavailability of the parent to perform supportive services may result in inappropriate placement or inadequate care. It goes on to say that for purposes of this section, full-time employment means working an average of 40 or more hours per week, regardless of work site location. A parent providing IHSS-funded care to his or her own child is not full-time employment. It then goes on into the next subsection, which is 4.452. For purposes of section 30-763.451, a suitable provider is any person who is willing, able, and available to provide the needed IHSS. A suitable provider who is a person having a duty pursuant to the Family Code need only be able and available to provide the needed IHSS. The person is only considered to be unavailable if that unavailability occurs during a time the recipient must receive a specified service for the following reasons: employment, enrollment in an educational or vocational training program, or employment searches. So it's been an old wives' tale for a long time that the non-provider parent in a two-parent household must work full-time, and that is just not true. I am now referring to document 15, all county letter 15-45, and I am referring to a section in this document. It's item 9, and it's on page 6, and it states here that a parent provider shall be paid for performing authorized services regardless of the presence of the parent in the home, including non-work hours, weekends, and holidays. In a two-parent home with one parent being the IHS provider, the other parent who is employed outside the home considered a suitable provider when they are available during non-work hours, weekends, and holidays. This is a question. And the answer is no. It states here a parent who is employed full-time is not considered a suitable provider if he or she is only available during non-work hours, weekends, and holidays. And it goes on to say that IHSS may be purchased from a parent under the condition that the parent has left full-time employment or is prevented from full-time employment because no other provider is available. And it references the section, which is 30-763.451. Then it goes on to state that this section refers to the presence of the other parent, non-provider parent in the home, and should not affect payment of the parent provider. The only reference made in the regulations about full-time employment is in this regard. And this is discussing the provider parent, not the non-provider parent. I am now going to refer to all county letter -19-02. And this is a clarification that was released just a couple of years ago, and this is in regards to that rule about whether or not the non-provider parent has to be full-time. And I'm reading here on page 5, and it's an area called Common Issues Related to Parental Full-Time Employment. And I'm 3 items down on page 5, and I've highlighted a section here which states, note, if the part-time work schedule is a result of the parent's responsibility to provide needed IHSS for the minor recipient, the parent would qualify to be a paid provider. So what this is stating is that the provider parent, if they work part-time, they can still be the provider for the child. They are barred from full-time employment, but they can work part-time and still provide services to the child. Continuing on in the same document, on page 6, there is a section that states suitable provider, and it's towards the bottom of the page. And what I've highlighted is the second part of this paragraph. It states here that a parent is only considered to be unavailable if that unavailability occurs during the time the recipient must receive a specific service due to employment, enrollment in an educational or vocational training program, or employment searches. What this means is it is not a requirement for the non-provider parent to be full-time. It is a requirement for them to be either employed or going to school or looking for work at a time that a specific service is being offered. And when it comes to protective supervision, which is 24 hours, 7-day-a-week supervision, obviously any hour of the day would apply, would meet this standard. Continuing on, same document, all county letter, 19-02. And by the way, this document can be retrieved on Google, and for those people who would like a copy of this, if you reach out to us, we'll be happy to provide this with you after this presentation. So on page 7 of all county letter 19-02, there is a section called determining if a parent is a suitable provider. And the first section states that in order to be a suitable provider, a parent must be able and available as defined by MPP section 30-763.452, which we already read, to provide the needed IHSS services. A parent would not be considered a suitable provider for any of the following reasons. And it states here that the parent is unavailable because of employment. And it says, note, parents who are employed an average of 40 or more hours per week are considered unavailable to provide services. However, a parent that is employed part-time is only considered unavailable to provide services during their hours of employment. Once again, there is that distinction again of the part-time versus the full-time. And then it continues on. It states the parent is unavailable because they are enrolled in an educational or vocational training program. They're unavailable due to employment searches. The parent is physically or mentally unable to provide the needed IHSS. And the last one, which is actually a new one due to the recently implemented overtime and the statutory maximum hours that a provider can provide hours as a result of the overtime rule. A parent is unavailable to provide care if they've reached one of the statutory work week maximums as defined in Welfare and Institution Code 12,300.4. So in a two-parent household, a parent provider who meets the requirements of MPP 30-763.451 can be paid as an IHSS provider for performing authorized services regardless of the presence of the other parent in the home, including non-work hours, weekends, and holidays. What this means is that if the non-provider parent has already been determined to be unavailable, perhaps maybe because they are employed during the time that a service is provided, or maybe for they're going to school, or because they're physically or mentally unable. What this is stating here is that if in fact that unavailability occurs episodically, it doesn't happen 24 hours, 7-day a week. It's, maybe they work Monday through Friday during a certain schedule, or maybe they go to school at certain hours of the day and it's full-time school, or whether they're searching for employment during certain hours and they meet the requirements of MPP 30-763.451. What this is saying that the IHSS can still be provided to the parent provider, the paid provider, IHSS paid provider, for the minor child, even if that parent is home on weekends, home on holidays, home in the evening after work. There used to be another old wives' tale that the moment the second parent walked in the home, that the first parent could not be paid to be an IHSS provider. That is just not true. So I'm continuing on through ACL 19-02. I'm now on page 8. And there's a section down towards the bottom that talks about authorization of two paid parent IHSS providers. Now, this is a situation that is recently developed because of the fact that there are some families that do have more than one protective supervision recipient in the household, and that combined together, the hours for both of the recipients would be over the statutory maximum for the one provider, which is 66 hours a week. And so because of this newly developed situation that's occurred in the last couple of years, the CDSS has implemented a new policy, and this is found in ACL 18-31. And what this states is, and I'm actually reading it from ACL 19-02. It says, accordingly, as set forth in ACL 18-31, CDSS will permit a second parent in the same household to also be a parent provider, a paid parent provider, when the first parent who is providing IHSS has reached the statutory work week limitation. The second parent may be paid as an IHSS provider to fulfill the remaining authorized hours of the minor recipients in the home once the first parent has reached the statutory work week maximum, as long as the second parent meets all the requirements of MPP 30-763.45. And what that means is, and it gives an example here, parent 1 is a paid provider to her 2 minor recipient children whose combined hours are 320 hours per month. The statutory work week maximum for a provider serving 2 recipients is 264 hours a month. Because she is no longer considered able to provide the needed IHSS services beyond the 264 hours, she is no longer considered a suitable provider for her children as defined by MPP 30-763.452. Parent 2 used to work full-time, but has been prevented from full-time employment due to the care needed of the children and the absence of a suitable provider. Therefore, parent 2 may be a paid parent provider for the remaining authorized hours. However, it should be noted that parent 2 is also limited by the statutory work week requirements imposed by the Welfare and Institution Code 12,300.4, which means that they themselves cannot cross over 66 hours a week. So in a nutshell, what we've discussed here is we've discussed the All County Letters 15-45, All County Letter 19-02, and All County Letter 18-31. And we've also discussed the MPP 30-763.451 and .452. And these are specifically designed to provide clarifications about the regulations in 2-parent households. And specifically, they've addressed scenarios in which you have perhaps maybe 1 recipient or 2 recipients, or I guess there's a possibility of even more than 2 recipients in a household. But these are the clarifications, these are the rules, and as I wanted to restate again, is that there is nothing in the regulations that states that the non-provider parent must be full-time. That is an old wives' tale. The regulation states that they must be employed or going to school full-time, or they are actively looking for work at a time in which an IHSS service is being provided. That is the standard. And then the regulations continue to state that as long as those requirements are met, even if that second parent is in the household on weekends, after they get off work, after they've done with school, after they've done doing job searches, whatever that circumstance is, the first parent is still allowed to provide paid IHSS services even if the second parent is currently in the home. And that's it.
Okay, we have one comment from Yvonne. If I offer IHSS for my mother, can I also provide an IHSS to my son?
Well, the IHSS provided to the mother. There is not a family code responsibility to that. The IHSS to the son, there is. And so if the son is a minor, then there is a family code responsibility. There can be no other able and available provider. The other issue that would be that should be considered is between the two, if the hours go over 66 hours a week, because that's regardless of whether it's one recipient or 1,000 recipients. You know, one provider can only work a maximum of 66 hours a week. So it is possible that you can be a provider for both your mother and also for your child. If there are, like I said, if the other conditions are met, if there's no other able and available provider for your son, if the lack of the IHSS would put your son at risk of out-of-home placement, you know, those would be the things to contemplate.
Okay, so that's the only question or comment, unless there's more coming in. But oh, there is someone. As a parent worker, can I get medical insurance and then after provide a secondary medical insurance for my son?
So this discussion is not about medical insurance, but I will tell you that I myself personally, I used to carry health insurance and secondary insurance because of my son's SSI, and then I recently learned in the last year that my primary insurance would not, they actually canceled my son for the primary because the SSI provided the Medi-Cal, and it disqualified my son for his first insurance. Is she talking about for?
She just put a clarification: medical insurance through IHSS.
So the IHSS insurance that's provided, at least in my county, which is Riverside, only covers the caregiver. And so yeah, you would have. I would assume if the IHSS that were being offered to your son was being offered through a federal link, whether it be SSI or whether it be the Medicaid waiver through Regional Center, you know, in both those scenarios, you would have the link to Medi-Cal for your son. And so you would have the IHSS insurance, which is only to the provider, which is something that's by itself, it stands alone. And then you would have the medical insurance for your child, which is provided through a different source, which would be the federal link, either through SSI or through the Medicaid waiver, or unless there's you know, the other possibility would be through Obamacare, and once again that would be a scenario for the parent, because you would have a situation where you would have conflicting insurances. You would have the potential to purchase your insurance as a result of your employer because of your affiliation with IHSS in your county. But then you also have the potential to get Medi-Cal if the income level is not to a certain level. So that would be another issue for contemplation.
Okay. Another comment, and I don't know what specifically the question is, but maybe you can address why she was denied. My son just got denied services because I work 32 hours and not 40 hours. I am the non-provider parent. My husband quit his job to take care of my son. He is not attending school in person.
I'd say they messed up. That's really just simple. If I'm hearing that correctly, you're saying that your husband left employment to care for your child, and that you are currently working 32 hours a week. And if that is correct, then they got it wrong. And if you're within your 30-day window to appeal, I would appeal that, because that clearly there is no regulatory. If in fact that's just how simple the judge's decision is, because I don't have the decision in front of me, and I'm unable to comment on something I don't have all the information on. But if it's just as simple as that, if the reason why your child was denied was based solely on the fact that you are working 32 hours a week and your husband is unable to work full time due to the need to care for your child, and protective supervision was one of the services that was being sought, then yeah, that's an error.
She added to it, she said, I spoke to the intake social worker today, and the main reason she denied it is that I am not able to provide a pay stub working 40 hours in a work week. She is wrong in denying my son's case then?
Correct. Because even, let me add an extra caveat to that. Because even if your child was denied because of the fact that you are not full time, which is it's wrong. That's just wrong. But even, let's assume that that was correct. Let's make the assumption that was correct. You still have the option of hiring a third-party provider during the times in which you are at work 32 hours a week. And the regulations also allow you, in fact, if you look at these documents we referenced earlier, the section we didn't discuss today was about the conditions for hiring a third-party provider. You still have the option of hiring a third-party provider under those conditions. And so they should still give you an approval or a denial for protective supervision, independent of whether or not you can be a parent provider.
Okay, next question from Yvonne. Can my daughter provide the IHSS for my son? She is 17 and is a college student.
So how old is, how old's the child? I need to know that too. Is your son over 18 or under 18? And my second question is, why is it that are you home or are you working full time? Because these are questions that are going to be directed towards.
She was the original question that had provider for her mom as well as her son.
Okay.
And she put he is 9.
Okay. So the rules for a minor, and like I said, this program today was specifically around parent providers. So we're going to touch a little bit, I guess, on third-party providers, because that's what the situation would be. Yes, your 17-year-old daughter could be a provider because she has the right to work in the United States as long as she has a work permit. I don't believe the 18 age is a requirement. I believe it's 16 years old, if I'm not mistaken. I do know of other situations. I think it goes county by county. But I do know of at least a handful of other situations in which a family member is providing services for the child in addition to the parent. But in order for you to be a provider, there has to be no other able and available provider. And if your daughter is able and available, then your daughter is going to be deemed to provide those services if you are not available. But you're automatically considered available because you're a parent. So if you're not working, like I said, I don't know all the specifics on this case. But if you are not working, then you're automatically going to be deemed the provider. If you're working full-time and you're barred from being a provider, then yes, you can hire your 17-year-old daughter.
Okay, next question from Kathy. Can you ask for an exemption so one parent in the home can take care of both children? That is what I was told.
Yes, that's called Exemption 2. And that's actually, once again, that's another topic that's covered in those documents that we talked about today. I highly recommend everybody that's on this call, these are all available on Google. So it was All County Letter 15-45, All County Letter 19-02, All County Letter 18-31. I would highly recommend reviewing these documents because, yes, there is an Exemption 1 and Exemption 2. Exemption 1 is an exemption that would allow for a parent provider to work up to 90 hours for 2 different recipients, but you have to be able to establish, once again, there's not a second provider, there's not another able and available provider to provide the hours beyond the 66 hours a week. That was actually an exemption that originally was grandfathered in for all the IHSS providers that were providing services to 2 or more recipients in the very beginning when the overtime was introduced, and they provided the follow-up changes to the statutes, the laws. But the second exemption is Exemption 2, and that is if in fact there are extraordinary circumstances that make it difficult for you to locate a second provider. And that would be in situations, say, if you live in a rural area, for example, and there's nobody else around you. That's the most common that I've seen for the Exemption 2. So Exemption 1 was something like that was introduced. It was more of a grandfathered exemption, and Exemption 2 that is for special circumstances. So there is potential to complete documentation and bring it to your social worker, and your social worker would either approve or deny the exemption.
Okay, question from Gayleen. I may need to read it myself because I'm still questioning the rule. We are grandparents who adopted our 10-year-old grandson My husband is ready to retire, but we cannot lose IHSS benefits.
So what's the question?
That's what you just.
I can tell you that in an adoption situation, when you adopt a child, you are also taking on the family code responsibilities. In fact, that's another subject that's discussed, and I believe it's in All Calendar 19-02. It discusses the distinctions between foster care and adoption. And in foster care, the foster parents are not considered to have the family code responsibility, whereas with the adoptions, there is an assumption of family code responsibility.
Okay, question from Cindy. Which county does this apply to? All counties in California.
That was the follow-up?
No, this is a different person.
Okay.
She wanted to know, is it all counties in California?
Oh yeah. These documents I'm reading are this is from CDSS. This is for the entire state.
Okay. So it looks like that is the last question. For those on the call, Andrew Ryder had posted a link. It's just a form, so if you guys want to fill it out, we can send them those documents. You don't have to search for them.
Okay.
But I guess that's it.
Very good. Thank you very much, everyone.